Good morning, everybody. Welcome to Foster Swift's What Employers Need to Know for 2022 webinar. We appreciate you joining us this morning. We have a very informative session and we'll keep the introductions quite short. The other thing I'd like to remind you is today's session is general information only, and we do encourage you to always check with your legal counsel prior to taking any action so that you know specifically how the law applies to your particular situation.
I'm going to be talking about getting ready for 2022 in some more general terms. You've probably noticed, I noticed this morning, it was a little darker this morning. It's getting darker in the evenings, starting to get a little cooler at night. Maybe like you, I'm already thinking about how I'm going to make my Thanksgiving bird this year. So it kind of feels like the year is, winding down just a little bit now. And to me, it feels like 2022 is kind of just over the horizon. So it's, I think it's probably a good time, to start thinking about next year, but we still have about, 2.5 months to go. So there's plenty of time to still get ready for next year. And so I think it's a good time to ask, how ready are you for 2022? What I've done to, try to help you get ready for 2022 is we basically developed sort of a self-audit that you can do so that we can sort of help yourself get ready for 2022. And for for people that have been in HR for, a decade or a couple of decades, some of this might seem, like old hat. I think for those of you who are newer to human resources and the human resources function, I think there's going to be a lot of good stuff in here for you to see and start thinking about. And then for, the people in between, hopefully there's going to be a few things in here to get the gears turning on getting ready. So the self audit that we've developed has really consists of three forms that we're gonna make available to you. And if you want these forms, they're sort of like checklists. Just ask Kim or chat with Kim, and we'll send you these three forms. But I'm going to be showing them to you here, and you can use these to perform your self-audit. But the three big questions that this self-audit really does is it asks, you should be asking yourself, do I have the appropriate employment policies, practices, and forms for the coming year? Do I know which employment-related statutes apply to me? And am I keeping the right records? Now, there's all sorts of other things that are important in your employment law practices and having what I call good employment law hygiene. But if you ask yourself these three questions and use the self-auditing tool, I think you're going to really be shaping yourself up for 2022. So the first form is regards this first question, and that is talking about what employment policies, practices, and forms do I need? And so we've created this checklist. And if you'll see on the upper left-hand corner, there's a column for the actual policy, practice, or form that we're going to talk about. And then you can check whether you have that policy. You can check whether you need to update that policy, or you can take some notes. Maybe you decide that you don't need that policy, or you don't have the policy and that you need one. So I'm just not going to spend too much time on any single one of these, but I want to go through this form with you. And again, you can get this form from us. So, and these are more or less roughly in chronological order in terms of the employment relationship, starting with what you would may want before you hire someone or even list a job opening, all the way through to the end of the employment relationship. So check your policies and forms and ask yourself, do I have written job descriptions for all the jobs, including, their essential job functions. This is very important when there are questions about ADA accommodations. Although these forms aren't conclusive on whether a job function is essential, it certainly helps to have it written down ahead of time and you're not backfilling it. I think it's a good idea if you do live interviews that you do a little training for interviewers regarding the interview questions. We could do a whole separate webinar on this, but there's good and bad ways to ask questions, and some questions you just shouldn't ask. But you want your interviewers to be aware of the basic parameters of good interviewing skills and what lines not to cross. I think standard offer and rejection letters makes life a little bit easier. Of course, employment agreements, we could do hours on employment agreements, but you want to review your employment agreements. When's the last time you updated those employment agreements? When's the last time you had a lawyer look at those employment agreements? Naturally, non-competition agreements that Cliff was just talking about, and confidentiality agreements. If you have information that you certainly don't want going to the competition or leaving the four walls of your organization, you can have employees sign confidentiality agreements. Do you need them? Do you have them? That's part of a good sort of checkup. You naturally want a good I-9 verification procedure with the forms that go along with that. You can't see the top of the slide, but you want acknowledgement of receipt for company property. Then you want, if you're going to give them company property, it's a very easy thing to do to just have a form that they sign that shows what company property they have. So when they leave, you know what they have and you can get it back. If you want to keep money for not returning company property, there's a special way you have to do that. You can't just do it. You have to have a signed agreement regarding a specific paycheck. So that's an easy form that you can have them sign in connection with company property. You'll want standard COBRA forms if you're doing it yourself. A lot of you probably have third-party administrators doing it. You want standard FMLA forms, which you can easily get from the federal government. But I know not all of you have those. And we can help you get those, or you can just go to the Department of Labor, get them from the Department of Labor. Naturally, you want to check your employee handbook. Again, this could be another at least hour-long webinar on employee handbooks. But when was the last time you updated your employee handbook? If it's been more than a few years, I really suggest you think about having that employee handbook looked at again. And I'm not going to talk about all the policies you want in your employee handbook, but there's some you certainly want. And one is an acknowledgement of receipt of the handbook. If you have to litigate these cases like I do, and there's a question as to whether the employee knew of a policy, believe me, what we want as Exhibit A is the acknowledgement with that person's employee's signature saying that, for example, yes, I understood that there was an anti-harassment policy and that if I was being sexually harassed, I was given an opportunity to go to multiple sources to report that sexual harassment. We really like those acknowledgements. You want an acknowledgement that you have a right to, in that acknowledgement, that the employer has a right to change the policies. You want policies regarding hours and overtime, and certainly any a policy related to any mistakes in pay. Naturally, you want to list employee benefits. You should have a social security number policy. And as I said, unlawful harassment and non-discrimination policies are absolutely essential. Next slide. Other forms you may want to consider, standard employee evaluation forms. If you're doing evaluations, it's nice to have a standardized form. It can avoid situations where different supervisors are doing their evaluations differently, and then you sort of end up with different results, which can be problematic if there's a discrimination lawsuit that you've treated similarly situated people differently, maybe inadvertently, simply because people are doing evaluations different and asking different questions. So a standardized form is always a good idea. Similarly, if you're going to do discipline or counseling or termination, a standardized form can help and frankly makes your job easier. A disability accommodation request form is a good thing to have, and a standard way of responding to requests for accommodations. And if someone's going to resign, a standard resignation form. And then finally, I think it's a good idea to have a separation checklist. There's about, I don't know, 4 to half a dozen things that you want to make sure you do when you have a separation, if you can get it done. So consider putting together a separation checklist for 2022. Next slide. So another thing you want to ask yourself is, which employment-related statutes apply to me? Because I think this, even if you go through this and you're just reading the names of these statutes, it should get the wheels turning and the juices flowing as to reminding you what your obligations are as an employer. Because almost all these, they all do have certain requirements for employers. And it's good to remind yourself that they're out there and to think about whether you are complying with them. And as you'll see, I list the statute, and then there's a checklist for whether it applies to you or no, it doesn't. And we can help you, figure out whether they apply to you. Some of this stuff is easily looked up. So we've got, Title VII, the main federal anti-discrimination statute, the Elliott Larson Civil Rights Act, which is the Michigan civil rights law. You've got Age Discrimination Employment Act, American with Disabilities Act, the Michigan Persons with Disabilities Act, which is the state version of ADA. And by the way, a lot of these, almost all of these statutes, whether they cover you or not, is going to depend on your size, which I'm going to just talk about real briefly. But next slide. You've got Immigration Reform and Control Act, the Fair Labor Standards Act, the Equal Pay Act, Michigan Workforce Opportunity Wage Act. You got OSHA, NEOSHA, FMLA, COBRA, and then the Uniform Services Employment Reemployment Rights Act, USERRA, which relates to non-discrimination against veterans. And again, you're going to want to ask yourself if these apply to you, and if they do, what are you doing to make sure that you do comply with them? Next slide. And then these as well, Michigan Wage and Fringe Benefit Act, HIPAA, WARN, ERISA, all things you need to be asking yourself. And again, most of these statutes is going to depend on your size. And as most of you probably know, if you're, for the FMLA, if you're 50 or more employees, these are for, I'm talking about private sector employers. If you're 50 or more, you have to be concerned with FMLA. If you're 20 or more, then you're going to need to follow COBRA. If you're 15 or more, the ADA, the federal ADA is going to apply to you. If you're 20 or more, the ADEA, Age Discrimination Act, is going to apply to you. For Title VII, it's 15 or more. Some of these statutes are just really if you have one employee. I can tell you that most of these statutes are going to apply to most of you, but not necessarily all of you. So then the last form that we can provide to you and to help you get ready and do a self-audit, next slide, has to do with, okay, there's some even more statutes. Go ahead to the, sorry. You remind yourself and ask yourself, what records should I be keeping? And who doesn't like to ask themselves that question? And for those of you who don't regularly think about record keeping, you can use this chart, which, so with this chart, just so you know how it works, on the left-hand side, that is a sort of a substantive explanation of what the actual substantive documents are, what information needs to be kept. And then on the, as you go down through the next columns, these are a variety of statutes, state and federal statutes that have record keeping requirements. And it's a little bit complicated, but you can tell from the footnotes down below, which you'll see what the names of these are. Yeah, those are the footnotes, so you know what the statute letters are for. But so you can see. So on the far left-hand side, that's the substantive information. Then you've got the different statutes, and then those numbers. So if you look at like from employment applications and pre-employment records, you go one column over, that's Title VII. So if you're 15 employees or more private, then that's going to apply to you. They have certain record keeping requirements, and then this will tell you how many years you need to keep that record under the statute. So you've got employment applications, next slide. You've got a variety of other records, including employment action records, so training, or transfers, discharge. You've got job descriptions, records of illness or injury. You've got employment, pension, and benefits records. All may apply to you in terms of some record keeping requirements. Now, these slides will tell you how many years you need them, but I would just say, as a general matter, and Mike and Cliff, you jump in if you have a different point of view, but next slide. My view is that if you want to be, next slide, is that if you want to be as careful as you can, the general advice is to simplify your record keeping, is to keep all of these records for 6.5 years. And what I mean by 6.5 years, 6.5 years after the end of the employment relationship. So think of it as keeping the records for the entire employment relationship, and then tagging on another 6.5 years after that. Now, that's not what the statutes themselves don't require, 6.5 years. But number one, it's easy because it's just only one number you really have to remember. And it's not necessarily to comply with the statutes, but it's to have these records available in the event that there's a lawsuit after the person leaves. So not to get too far in the legal weeds here, but the most likely longest statute of limitations that would apply to an employee who leaves you would be a breach of contract action if they had some sort of contract with you. The statute of limitations on that is 6 years, which means after the person, for example, is fired, a 6-year clock starts ticking, and that employee has to file their lawsuit within 6 years. That's about the longest one that would apply to an employment relationship. And then so there's a 6-year clock. I like to do 6.5 years because there may be a lag between when the person leaves and when they first become available of their claim. And it might take a little while for you to actually get that complaint, even though it's filed. So my rule of thumb is 6.5 years to keep those records. So if you get a chance, take a look at that chart, decide what records you need to keep, which you should be keeping, review your record keeping practices, and that'll help you get ready for 2022. So that's all I've got. Like I said, if you want these forms and you want to help us help you do an audit, we can get you those records. And I think we're getting close here to the tail end. And I guess you can, Kim, if you want to open it up for questions for my learned colleagues.